right, so let's go on the record on cause number DC 2017615 Pavilion Bank versus Healthy Happy Pets LLC. Counsel, make your appearance.
Rebecca Vaughn, Your Honor, for the plaintiff, Pavilion Bank.
Scott Anderson for the defendants, Happy Healthy Pets and Pet Healthy Holdings.
Let's proceed.
Thank you, Your Honor. Again, I'm Rebecca Vaughn on behalf of the plaintiffs, and we're here today requesting a partial summary judgment against the defendants, Happy Healthy Pets LLC and Pet Healthy Holdings LLC. Specifically, we're requesting the summary judgment as to those defendants' liability for breach of contract claim, which is the only claim that we have asserted. The amount of damages that we have incurred as a result of that breach is not going to be before the court today. Your Honor, the facts in this case, I believe, are fairly straightforward, and for the most part, I do not believe are disputed by the parties. On October 6th of 2011, Pavilion granted a loan to PEB Direct, Inc., which plaintiff will refer to as PEBD, in the amount of $150,000. Pavilion was and still remains the holder of that note. That note was secured by all assets of PEBD, including inventory, work in process, raw materials, equipment, and receivables. Due to financial hardships, however, PEBD entered into an agreement with defendant Pet Healthy Holdings, which I will refer to as PHH, on October 4th of 2013. PEBD in that agreement decided to sell all of its assets to PHH, and Pavilion was involved in that transaction and agreed to same. Importantly, the agreement between those two parties specifically referred to PEBD's notes with Pavilion and provided specific terms as to how PHH would satisfy that obligation to Pavilion moving forward. For example, PHH was to pay Pavilion the sum of $25,000 through installment payments as partial satisfaction of that note. And after that amount had been paid in full, Pavilion would release the liens that it had on PEBD's assets that PHH was purchasing. At the time that PEBD was sold to PHH, the balance on that note was $133,849.79. The PHH agreement further provided that PHH would pay to Pavilion royalty payments from the sale of products that they sold at certain percentages up to a maximum amount of $150,000, and that such payments would be specifically credited against PEBD's remaining obligation to Pavilion. Pursuant to that agreement, PHH did make periodic payments to Pavilion from the installment payments as well as the royalties. After some time passed, PHH then entered into a membership interest purchase agreement with Healthy Happy Pets LLC, the other defendant in this case, which I will refer to as HHP. I apologize if all the acronyms are getting a little confusing. HHP was a newly formed entity that was created by the same owner and member of PHH, and his name is Mr. Walter Stock. Both of these companies are still in existence today, and both are still wholly owned by Mr. Stock. In that purchase agreement, PHH would be wholly assigned to HHP, and specifically in paragraph 3.7 of that agreement, PHH and HHP specifically stated that HHP was to assume all of PHH's contractual obligations to Pavilion. Walter Stock, on behalf of HHP and also PHH, confirmed this obligation on numerous occasions to Pavilion, and that PHH and thus HHP were obligated to pay those royalties to Pavilion. There's really no question that PHH intended to honor this obligation when it assigned to it by PEBD, as this intention was shown through the detailed provisions of the agreement and as well as the actual payments that were made to Pavilion by PHH. Therefore, Your Honor, by the subsequent agreement between PHH and HHP, wherein HHP acknowledged the debts that were still owed to Pavilion by PHH through that agreement with PEBD. It agreed to assume the same and likewise accepted that obligation. Numerous demands have been made on both HHP and PHH to satisfy this debt, and neither party has acknowledged the obligation, nor have they made any more royalty payments since the time that the company was wholly assigned to HHP. By this motion, Your Honor, Pavilion Bank has proved all elements of its affirmative claims against PHH and HHP, specifically that breach of contract, and seeks summary judgment in its favor as to defendant's liability. Thank you, Your Honor.
So I'm kind of looking at this because all these different acronyms are a little confusing. So you moved for summary judgment against both, but there was only a response as to one. Is that right?
Response in this lawsuit, Your Honor?
A response to summary judgment.
Both defendants made a response to
They did,
summary
okay.
judgment.
All right. So, all righty. Well, then, why don't you show the documents that kind of put the key document that puts HHP and PHH kind of on the hook for this particular loan?
Absolutely, I can do that, Your Honor.
You
And
can
we've
share
also
screen.
attached, yes, I can do that. Here's the agreement between PEBD, the initial company that actually was the borrower for the note with Pavilion Bank, and Pet Healthy Holdings. And I believe it's on under 4, under consideration. We have this $25,000 amount that says they'll be paid in monthly installments. And on the next page, Your Honor, it does note the lien right here. And then on the next page, it says that these shall be made directly payable to Pavilion Bank to satisfy that loan against the raw materials, and Pavilion Bank would remove its lien at that point. And then under E, we have the royalty provision that gives Pavilion Bank the up to $150,000 in royalty payments that were to be made by PHH from products sold.
Okay. Response, Mr. Anderson?
Yes, on those 2 points, Your Honor, on that particular provision of the asset purchase agreement, the B, I don't know if I can move her. No, I can't. On B, it says the direct right there. The direct obligation of PHH is to pay PEBD $25,000. And under the law in Texas, to have a third-party beneficiary or to create a contract, that is not a contract between Pavilion Bank and PHH. It's a contract between PHH and PEBD. So there's no agreement there at all between the bank and PHH.
And explain why the bank wouldn't be a third-party beneficiary. I don't think I quite understood your argument there.
You asking me? Yes. Oh,
Yeah, Mr. Anderson.
yes. I'm sorry. Because there is nothing to assume here. The note would be what would be to assume, and there is no mention of the note in 4B. It's a separate obligation to pay PEBD a royalty amount of up to $25,000, and then in the same provision it says that PEBD authorizes PHH to pay that amount, whatever that is, to the Pavilion Bank. So under the law, the agreement is between PEBD and PHH. And if there's an obligation to enforce, it's not by the bank, it's by PEBD. That's who has that obligation. The first 6 words or so to pay PEBD the amount of $25,000 for raw materials.
But if you go down later on in that paragraph, could you go down a little bit on the paragraph? It says shall be made directly to Pavilion Bank to satisfy Pavilion Bank's lien against the raw materials, finished products, and work in progress. I just don't understand why that wouldn't be a third-party benefit, why the bank wouldn't be a third-party beneficiary with that language.
Oh, because, I'm sorry. For the first bank of versus Brummett requires a direct obligation, and the direct obligation is only by PHH to PEBD. If PHH breaches this agreement, which it would be enforceable by PEBD, not by Pavilion Bank. And we have language that we have factual evidence from Jeff Ballard that it was not the intent to benefit Pavilion Bank directly under this provision. So we have a factual issue in which we need to explore further, and it's not in any of this yet because we're so early in this case that the bank ended up repossessing all the raw materials, finished good, and work in progress. We're just not at the point in that case where that fact has even had a chance to be developed yet.
So there would be some kind of offset is what you're saying?
Yes, there would be an offset. And also there was a breach of their agreement. The Pavilion Bank's agreement was to receive whatever royalties there were, whatever they were, but not enforce, but release its lien. Instead, it repossessed all.
They agreed to release the lien without being paid for it?
Well, that's a factual issue that would be something for the court to consider, but not for summary judgment, in my view.
Okay, can we go back up a little bit?
Yes, and Your Honor, if I may,
Okay,
we
so
do acknowledge that.
I'm sorry, go ahead, Ms. Vaughn.
We do acknowledge that there are credits that need to be applied here as a result of repossessing those assets, which is why we are not seeking the amount of damages at this time. We understand that further discovery and calculations need to be done. We're just here as to liability.
Okay. All right, so so you have a summary judgment against PHH, I'm sorry, an HPP, is that what it is? PHH?
PHH.
HHP and PHH.
So based on this, I'm going to grant summary judgment in your favor as against PHH. Now, what's the basis against HPP?
The next purchase agreement, Your Honor, which was the purchase agreement made between the two companies that are really more of a continuation of those companies. They're owned and operated by the same individual. And this is their purchase agreement, is listed as A2 under 3.7 of this agreement. It specifically says that the contracts which will remain in effect after the closing of this contract is that with Pavilion Bank and Troy Merrick.
The contract, okay, I don't think I understand. Maybe don't see the whole picture here, but it says the contracts which will remain in effect after the closing of the contracts with Troy Merrick and Pavilion Banks. The contract, do they assume the obligation for that, or just say that the contract still exists between the original obligor and the bank?
Yes, since the seller here is PHH, which is the first company that was assigned to this note, in the previous document we just looked at, this is saying that HHP, who is the purchaser, is taking all the assets subject to Pavilion Bank's agreement with PHH.
Response? Mr. Anderson?
Yes, Your Honor, this is this is not an asset purchase agreement at all. It's the sale by Quality Logistics System of its interest in PHH to Happy Healthy Pets, HHP. And there is nothing in here that a shareholder or a limited liability member is liable for the debts of its owner. It's not a continuation of the business. It's nothing moved from Pet Healthy Holdings to Happy Healthy Pets. Nothing moved. And at the beginning of this is not this section 3 of this agreement. If we go back to the beginning of section 3, right there, this is seller is Quality Logistics Systems. It represents and warrants to the purchaser, which is Happy Healthy Pets, these things. And so there is no agreement here at all by Happy Healthy Pets. Not an agreement to assume any note, not an agreement to assume any contract of Pet Healthy Holdings, nothing. It's a change of ownership. That's it. It's not and the fact that they're now arguing some sort of continuation of business, first of all, it doesn't make sense. There's no assets moved here. It's just a change in ownership. And under 101.114 of the Texas Business Organizations Code, a limited liability member is not liable for the debts of the Pet Healthy Holdings. This is a stretch of what this agreement is, a stretch of the law, and there's nowhere in there does it say Happy Healthy Pets agrees to assume anything. It's only a representation of Quality Logistics System. Under that first paragraph, Quality Logistics Systems is making that representation. Happy Healthy does not make any representation or any agreement about any liability.
Kind of agree with them on this. I don't see where they assume this liability. Maybe there's something else that I just have missed. Ms. Vaughn.
And Your Honor, the very first paragraph of the agreement makes this clear that the contract is between Healthy Happy Pets, the Quality Logistics Systems that he referred to, as well as Pet Healthy Holdings, which I believe is owned by the seller.
But
Logistics.
the part you showed that it indicated the contract would remain in effect. It didn't say that HHP was going to assume the obligations of the contract, at least that I can see.
Your Honor, let me find the exact paragraph.
That's the one you showed.
Your Honor, 3.7 is the one where Pavilion Bank is specifically referenced as having a liability for any of these parties that is going to continue. And whether that means it's going to continue as the PHH or HHP, I guess, can be argued here.
Okay. I'm going to deny the summary judgment as to is it HHP? So granted as to just as to liability for, I'm sorry, PHH, but
yes, Your Honor.
Granted as the PHH, denied as the HHP.
Your Honor, I have a question on PHH on the summary judgment. Is it just as to that 25,000 4B provision in that agreement, or because we never got to 4E, which concerns the other royalties that they've claimed are due from PHH?
It's for all the duties under that contract, or I guess all the. You're right. It's just the 25,000 because that's what they were supposed to pay directly.
All right. Thank you.
So, Ms. Vaughn, if you could go ahead, and I'm sure you don't have an order that says exactly this. So, if you could prepare an order that says that. On the order, if you could include at the beginning where it says on this date, if you could include this particular date. So on April 12th, blah, 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 and share it with Mr. Anderson, and then give me a copy, the details, the terms of these rulings.
Thank you.
I can do that, Your Honor.
All right. And make sure you email that to my court coordinator as well as e-filing it. Okay.
I can do that.
All right. Thank you guys. You guys be safe.
Thank you, Your Honor.
Thank you, Your Honor. You as well.
All right. Bye-bye.
Where do I get it?
Well, a lot of our hearings have canceled today. Oh, oops, thank you.